There is a mechanism called the Classified Annex. It appears in no law you have ever read, and it has been attached to federal legislation since 1947, shaping how your government spends money, deploys force, and defines its own reach. You will never see it. Your own representative may not have clearance to read it, and it carries the full legal authority of any statute Congress has ever passed. Every year, Congress passes the National Defense Authorization Act and the Intelligence Authorization Act. These are public documents debated, amended, published, signed into law. What is not published is the Annex. The Classified Annex is a separate document, sealed from public view, attached to that legislation. It contains binding appropriations, operational directives, and legal authorities. It has the force of law. It is subject to the same presidential signature that makes the parent bill binding. But unlike the parent bill, you are never permitted to read it. Most members of Congress cannot read it either. Access requires a specific clearance and committee assignment. The representative who voted to pass it may have never seen what they authorized. This did not begin with a law. No vote was ever cast to create the Classified Annex system. It grew from executive practice, legitimized by classification authority tracing back to President Truman's Executive Order 10,290, signed in 1951. Congress did not create that authority. No legislature voted on the mechanism that would allow laws to contain hidden provisions. The National Security Act of 1947 gave the Director of Central Intelligence the duty to protect intelligence sources and methods. From that mandate, sealed legislative annexes developed, not through statute, but through institutional habit formalized over decades. By the time the Church Committee exposed intelligence abuses in 1975, classified annexes were already so embedded that the committee could not fully read the CIA budget it was supposed to investigate. The system predates any public acknowledgement of its existence. Control over classified annexes does not rest with the full Congress. It rests with the Gang of Eight, the Speaker of the House, the Senate majority and minority leaders, and the chairs and ranking members of the intelligence committees. 8 people out of 535. The executive branch decides what those 8 are shown, and once briefed, they cannot disclose what they have learned to their own staff, their colleagues, or the public, even if they believe what they've been told is illegal. The briefing itself becomes the trap. Here is where this reaches you directly. The Classified Annex authorizes programs with real budgets affecting real infrastructure. The NSA's bulk telephone metadata collection program, revealed in 2013, was not rogue. It operated under a classified legal interpretation of Section 215 of the Patriot Act, an interpretation so expansive that its secret meaning bore no resemblance to the public text. The Intelligence Committee chairs knew. The program collected the records of over 300 million Americans. None of them were told. None of them voted for it. In that same year, Snowden's disclosures revealed the intelligence black budget totaled $52.6 billion. The public had never been given that number. The government had spent the money legally with congressional approval, and that approval existed in documents the public had no right to see. Remember, no one voted for this. The program was legal. The oversight was real, in the narrow sense that 8 elected officials were informed, and every element of it was sealed from the people it was built to protect. This is not a scandal. It is the system working exactly as designed. You cannot repeal a classified annex because you cannot name what you are repealing. Legislation requires a public record, a bill number, a section, a text. Classified annexes exist outside that record. A congressman could draft a bill to prohibit them entirely, and that bill would be reviewed by intelligence committees, who would classify the portions of debate they found sensitive. The mechanism protects itself by the same authority under which it operates. The classification power is executive. Congress granted it to the president in 1951. To revoke it requires either new statute, which the executive can resist through national security claims, or an executive order revoking a prior executive order. That has never happened. And here is the part that should actually worry you. It is completely legal. Every institution you rely on to check this operates from the public record. Federal judges reviewing national security cases receive sealed courtrooms and cleared counsel. Inspector generals who discover wrongdoing in classified programs are required to report through the same oversight structure that classified the program. Journalists who receive leaked materials face prosecution under the Espionage Act of 1917, a law that no one alive today voted for. The oversight is inside the system it is supposed to check. The accountability structures are built from the same authority as the thing they are meant to oversee. The classified annex does not exist despite the system. It is the system. What you should be asking now is not how many classified annexes currently exist. No public count has ever been released. The question is simpler than that. If a law can be passed with a portion you are not permitted to read, is it still a law? Or is it something else entirely, wearing the name of law, but answerable to no one you will ever see?